Ever found yourself in a legal maze wondering whether your estate application needs consent or renunciation? Imagine you're handling a matter where your client is the child of the deceased and there are other children and the spouse is still alive. But you're not sure which one you require for who. Is it consent or renunciation? So you just opt to do both in one document. No. Hi estate hackers, welcome back to another insightful session here at EstatePro Academy. Firstly, a huge thank you for the overwhelming support, questions and interest. To our new subscribers, y'all are the real MVP. And for the rest of you, don't forget, hit that notification bell to stay updated on all the invaluable content we have here to share. So let's dive into today's topic. I get it. The title says order of priority, but in the intro we touched on consent and renunciation. So now you're a little bit confused, but stay with me here. Many times you struggle through your estate application not really knowing the exact documents to exhibit because there's a gap. A gap in some of the fundamental principles and practices in estate law. No shame in that. We've all been there. We all know that what we learn in law school merely skims the surface of law. I remember probate was my least favorite class because I just didn't understand what my lecturer was talking about. Fortunately for me, I had the opportunity to immerse myself in this area of law, and now it's second nature. And that's why I'm here to help you. But I digressed. Today we're going back to basics, breaking down the very essence of estate administration, the real fundamentals of what is required to successfully file an estate application. You might be thinking, come on, get to the point. What is it? Easy, I'm getting there. For me, the single most important thing you must know in estate law is the order of priority. Just understanding who has priority in making the application and whether the client in front of you is that person, and if not, who do they have to clear off to establish their right to accessing the grant. So let's dive into the law. Section 30 of the Wills and Probate Act lays down the rules here. For TESTACY, we follow Section 30B, and it states that if no executor is appointed or the executor is absent or unwilling, the order of priority is a residuary divisee or legatee, then a divisee or legatee, then the next of kin, basically following intestacy order of priority, and finally the administrator general. For cases of intestacy, we follow sections 30A, and it outlines the following order: the surviving spouse, then the next of kin, and finally the administrator general. The administrator general is always last resort if there is absolutely no one to be found in the deceased bloodline. Now, understanding this in theory is one thing, but having a clear visual chart really changes the game for you. A free TESTACY and intestacy chart has been created just for you by EstatePro Solutions Company Limited. They are the sponsors of this video. See the link in the description below. Now let's look at the TESTACY chart. Here you can see clearly a hierarchy of who comes before who, making it easy to know where your client stands in the process. Now, the executor, that is a sole executor, one of the executors, or a surviving executor, always has top priority. This is followed by a named alternate executor. Once the chain of representation is broken, consideration is given to persons with lower priority, that is, a residuary devisee or legatee, then a devisee or legatee, next of kin, or the Administrator General. It is important to note where there are two or more persons in the same class of entitlement, they are all equally entitled to making the application, and so they must be cleared off or join in the application. However, for any persons in a higher class of entitlement, they would have prior rights to making the application, and so must also be cleared off or make the application themselves. So let's look at an example. Your client is one of the devisees or legatees named in the will, and there are two other devisees or legatees, a named residuary beneficiary and an executor. Your client, the devisee or legatee, must clear off those persons with equal and prior entitlement, and this will inform the documents that is required to achieve same. For persons with equal entitlement, they can be cleared off by death certificate, notice if they are outside of the jurisdiction, consent, or renunciation. This is for persons with equal entitlement, that is, the other two devisees or legatees. However, for persons with prior entitlement, that is, the residuary devisee or legatee and the named executor, they can only be cleared off with a death certificate, notice if they are outside of the jurisdiction, or renunciation. You cannot clear off someone with prior entitlement with a consent. This is fundamental. You can clear off persons with equal entitlement with a consent or renunciation, but you cannot clear off someone with prior entitlement with a consent. It's a renunciation only. Do not renounce and consent at the same time. Consent and renunciations serve different purposes and can have unintended consequences. So let's do a quick recap on the order of priority for testacy. First, it's the executor, then it's the alternate executor. Once the chain of representation is broken or the executor is unable or out of the jurisdiction, then it is a residuary devisee or legatee, then a devisee or legatee, then the next of kin, and finally the Administrator General. Now let's turn to intestacy. Now warning, this is on a spectrum and it can range from very simple to extremely complex depending on who the deceased left surviving him. Now at the very top of this hierarchy is the legal or common law spouse of the deceased. If the applicant is one of these persons, you will know straight away that you must exhibit the marriage certificate or cohabitational order from the court. Simple, right? Next in line is the children and any issue of a predeceased child of the deceased. Wait, what? Yes, let me repeat. Next in the order of priority for intestacy is the children and any child of a predeceased child of the deceased. Basically, the grandchild. If you've ever seen the query, did the deceased child have any children who predeceased him? If yes, were there any issues of a predeceased child? If yes, child to consent, renounce, or join in the application? This is why. Children of any predeceased child stand in place of that person. For more on this rule, check out a principle called Stripatal Interest, or see Rule 22 of the Non-Contentious Probate Rule UK for more guidance. So, if a child is applying, The test on this chart will be, are there any other children or children of a predeceased child? If yes, a death certificate, notice, consent, or renunciation will be required to clear off those persons with equal entitlement. Now, because it is intestacy, you must depose of the marital status of the deceased, whether male or female. This means that you are required to clear off a spouse even in cases where there was never one. Now, I know what you're thinking. How do I do that? Well, if the deceased was never married in their lifetime, the applicant must depose that the deceased was a bachelor or spinster. Note, single is not a marital status. I repeat, single is not a marital status. You could be single and divorced, single as a widow, or single as a bachelor or spinster. Single is not a marital status. So, if the deceased died a widow, divorced, or with a surviving spouse, clearing off documents will include either a death certificate, divorce absolute, not nisi, marriage certificate, and the renunciation if the spouse is still alive. Remember, since a spouse has prior entitlement to apply, once they are alive, they are required to provide a renunciation and not a consent. Now, this rule can be applied for all levels of this intestacy hierarchy. You place your client based on their relationship with the deceased. Then you determine whether there are any persons in the same class and a class above to be cleared off. Clearing off must be done by death certificate, notice for persons outside of the jurisdiction, consent or renunciation for persons in the same class of entitlement, and renunciation only for persons who are in a class above. So, let's look at one final example. Let's say the father of the deceased is applying. Who would be in the same class? That's right, the mother. Who will be in a higher class? The children, grandchildren, and spouse. A simple scenario is the deceased died a bachelor without issue in his lifetime and his mother is deceased. Simple, right? But if the mother is alive, a consent will be required or notice if she's outside of the jurisdiction. Whereas if there were any children, grandchildren, or spouse of the deceased, a death certificate, marriage certificate, divorce absolute, birth certificate, notice, and renunciation is required if any of those persons were alive. There you have it, estate hackers, the order of priority in a nutshell. It's really super simple once you get familiar with it. Place your client on the chart, identify the equals and clear off those above. If equals are alive, a notice, consent, or renunciation is needed. For those with prior entitlement, it's a notice if outside of the jurisdiction or renunciation, not consent if they're within the jurisdiction. Understanding this hierarchy isn't just theory. It is your secret weapon in estate administration. So don't forget, grab your free TESTACY and INTESTACY chart using the link below. And if you found this breakdown helpful, hit the like button, subscribe, and stay tuned for more valuable insights. I am Tovalyn Sandy signing off from EstatePro Academy. Until next time, keep hacking those estates one step at a time. See you in the next video.